at ease, Mr. Turner.
Lady, can I just say the documents that were being asked for?
Oh, yes, please.
We've got Charman and Charman, although I'm afraid we've only got it at the moment in the Bailey print, not the best in the hierarchy of authorities. As far as I can see at the moment, the references to computation are in paragraphs 57 and 87
Thank you.
of Charman. Although they don't, it doesn't seem to speak specifically about prospective liabilities. And we have also the Form D81.
Thank you.
If I could hand that up as well, please.
Thank you.
Sorry.
Thank you, Mr. Turner. And unless you've anything to add, I don't think Justice Snowden wants to ask any further questions.
Emily, the only point that I want to add or to emphasise is that our concern, and this perhaps is not a matter for this court at this stage anyway, it may be a matter if the matter has to go back to Mr. Justice Peel at some point for him to decide, whether any damages that are actually awarded come off the top automatically, or whether have regard to has a broader meaning, because otherwise it would mean that someone with a non-proprietorial claim would have that satisfied, whereas a wife, because it's usually the wife still, whose endeavours and earned entitlement would come for naught. And we say that's a potentially important policy point. But as I say, that probably doesn't arise for this court at this stage. But we say there's no reason in those circumstances why a wife shouldn't have an order that's provable in bankruptcy as a matter of policy.
Thank you. Yes, Mr.
Thank you very much, Lady, my lords. As I say, I'm not going to repeat what's in my document, indeed in the submissions that I made below, or indeed what Mr. Turner said. But I want to emphasise, and I'll come back to bankruptcy, not discussed at all before Mr. Justice Peel, not raised by anyone. And indeed, the application here is obviously for the matter to go back before Mr. Justice Peel when that matter could be debated as to whether he does in fact approve. But I did want to say something about bankruptcy since it's been raised, that it's perfectly just for this wife to be able to prove in the bankruptcy, and perhaps it's not been abundantly clear, but much of the property that is in my client's hands was acquired before the alleged wrongdoing.
I don't think anybody is doubting that a wife can prove in her husband's bankruptcy. I think the question is, what for?
Well, yes, but I was really, I hope, going to address that point, what for. There's no reason why she shouldn't be able to prove, we say, for the 95 million or whatever it is. And as I say, much of the property was acquired before the alleged wrongdoing, including the London matrimonial home, which was acquired in 2009 and is worth in the region of 60 million. And just so the court is aware, my client does have other interests in Ukraine. Of course, what's going to happen to them is debatable, but which has got nothing to do with the bank or the wrongdoing. And the loans that are at the cornerstone of this proposed consent order, that were loans that were made by my client or one of his companies to the trusts, were all made before 2013, when the bank said that the wrongdoing started. So we say that's an important background why, if it's said that there's any sort of prejudice in my client proving, in the wife proving in the bankruptcy, there isn't really. The age point, far from me at my age saying that 61-year-old is vulnerable, but it is really the particular circumstances of Ukraine, and it goes a bit further than just being Ukraine, and I'm not going to spell it out in an open court, but page 44 of the supplementary bundle deals with concerns that are peculiar to the co-defendant and in the Chancery proceedings, and indeed by association, my client.
Oh, yes, I remember.
So, I mean, it's not that he's 61. I mean, obviously anything, as Mr. Turner says, anything can happen to a 61-year-old, but he is in Ukraine, and that witness statement, of course, goes into the position that he's in. And, of course, he has been in Ukraine throughout, I believe, throughout the period of the invasion, special operation, whatever one calls it. So that's that. I wanted to sort of say something about unfairness, because we've heard a lot about this, but let's look at it from the current perspective, not what necessarily might happen. If of course, and predicting as much as one can, which is what Section 25 enjoins you to do, if my client is successful in the Chancery proceedings, well, he will have, and an order is made, there will be an order which transfers 4% of the assets to the wife, a really very small proportion. Of course, if he loses, and it was canvassed the question of whether he could revisit the order, if there is an order, well, the answer is he can't. He couldn't visit under the BARDA jurisdiction because it's not an unknown, it's completely foreseeable. And there's no way. And of course, if he loses hands down, he is going to be in a bad situation, prima facie. But of course, he is an entrepreneur, a businessman, he's 61, who has obviously enjoyed a lot of success in his life. And of course, men like that are entitled to say to the court, well, fine, predicting I may well be in a bad situation, but I will resurrect myself. And that's what he would have said had we got onto the approval part of the hearing. And of course, if he loses outright, the wife's position is that she will only be able to prove at a maximum of 4% of the total assets. If one assumes they're 4 billion, if one assumes they're more, it's less than 4%. If they're less, then it's obviously more than. But it's not a huge proportion. Can I then, Charman, I looked at briefly over the shorter adjournment. Charman, I think, also says something about computation at paragraph 67 as well. And it says nothing, as far as we could tell, about computing liabilities, that it was essential to compute the liabilities. It is obviously, it is essential to have some computation, but often it may well be that the computation involves liabilities which may or may not accrue. And a good example is, which arises so often in these sort of cases, is that there is a real worry that HMRC are going to say, we don't like your tax returns, we're having an inquiry now, and there may be penalties, there may be interest, and every so often you get cases which husbands say, well, if that happens, I may be wiped out. But that doesn't preclude agreeing an order in my submission. And the next point I wanted to make is there was a debate early on this morning about the word property in section 24. I'm really dealing with something my Lord Justice Snowden said. Yes, it is right that there is that reference to property, but one mustn't forget that a property transfer is not the only outcome of financial provision proceedings. In section 23, excuse me, there is power, obviously, to order a lump sum, which is unlimited power. And that is a freestanding power available to the court. And it does not require particularizing any particular property or identifying it. So it is not a precondition of any order, we would say, to identify a property. And
sorry, I don't think that was really what
have I missed the point? I'm sorry.
I don't really think my question was directed at that. I was first of all just wanting to know what the statutory wording was in relation to transfers of property or dispositions of property.
Which Mr. Turner did.
Yeah. and it's obviously broad.
Yes.
Winding back a little bit, I don't think anybody, as far as I'm aware, is suggesting that there's no jurisdiction to make an order. The question is really whether it should be done in circumstances where there's a very large liability potentially attending the assets available for division between the parties.
Yes, but, well, maybe my emphasis is misplaced, but I just, excuse me, I just wanted to make it clear that you do not have to identify property. And very often you have cases, and bearing in mind this is an agreement, this is not a trial, this is a proposed agreement, where, as I put in my note, a husband says in his Form E, which he has to produce to declare his assets, well, I'm underwater. If this and this happens, there's nothing. And then the wife says, nonsense. And the matter comes, as all these cases have to, and bear in mind that the majority of cases do settle way before this, but the matter comes before a financial dispute resolution. And on the face of it, the husband is underwater. But then he agrees to pay 10 million. And if that's the case, the judge doesn't say, oh, where are you going to get it from? And to start scrutinizing it. Because the whole jurisdiction of approving orders is very much to protect the weak. But if a husband who is an entrepreneur says, well, I will agree this order, then the court is likely to approve it. And bear in mind that this is an agreement between two parties who were competently, I hope everyone will agree, represented over a very long period at very considerable cost. We put in a Form H before Mr. Justice Peel to indicate that the husband's total cost was 300,000. The wife's, no doubt, very similar. So this was not an order, and bear in mind there was a double negotiation. There was a negotiation leading up to the separation agreement. Then the separation agreement has to be put on ice because of the Taft-Neft injunction. And then when the Taft-Neft injunction is discharged, because the Taft-Neft litigation goes against them, then my client becomes obligated under the separation agreement to implement it. And so the negotiations start again to turn it into an order. So this is not something that was conceived at the door of the court without proper consideration. It was, before it was oven ready, as my learned friend Mr. Turner put it, it was on the table, roughly, for nearly 5-6 years. And so it is an agreement. And the considerations in the case of George, we say, are not really appropriate to this, because that was in relation to a trial. If you have a trial of a financial provision application, obviously the judge is enjoined to make more precise findings. If someone raises that there's a debt and the other party says there's not a debt, then the judge has to make findings. But you don't have to make findings in order to arrive at an agreement. And I would postulate that the judge, and indeed my lady said, well, if the husband had said, I want an adjournment, would he get it? Well, he would. I accept that. But that's, with respect, is not the test. The test is, if an FDR judge was told, say the bank is not there, is told, look, these two agree, they've had very proper representation, the judge we would submit, have made the order. He might have interrogated me and said, are you sure that your client wants to agree this? And of course the reply would be, my client is a sophisticated adult man of the world, and he has taken a view. And he's entitled to take that view. And he can say, look, I'm not just prepared to wait 2 years, I want this finalised. And it will be 2 years. The trial is not even meant to end until middle of November of this year. And so there will be very considerable delay. And he's entitled to say, I've spent all this money, I want an order made. And we say that it's really a bit of the court knowing best if the court says, I'm not going to make this order. And I rely on the two paragraphs in Granatino. One in the bundle, it's tab 13, 156. Headed autonomy, paragraph 78. Reason why the court should give weight to a nuptial agreement, and the authority made it clear that applies to all agreements, and including this agreement, is that there should be respect for individual autonomy. The court should accord respect to the decision of a married couple as to the manner in which their financial affairs should be regulated. Well, twice these couple have regulated their financial affairs, both in the separation agreement and coming before the court. It would be paternalistic and patronising to override their agreement simply on the basis that the court knows best. This is particularly true where the parties' agreement addresses existing circumstances and not merely the contingencies of an uncertain future. These parties address both. And then if you go back to paragraph 75, in the sentence just beginning above H, the problem arises where the agreement makes provisions that conflict with what the court would otherwise consider to be the requirements of fairness. And the conclusion...
Isn't this dealing with the situation between husband and wife,
Yes.
where there are no external third-party rights or claims? I mean, I fully understand why if nobody else is involved, all their debts have been paid, the court shouldn't just as a paternalistic matter say to a husband and wife, well, I don't think you've made the right deal. I think I'm not prepared to deal with it. I'm going to interfere. But the argument in the instant case, our case, is that it's not just simply a decision as to the manner in which the financial affairs of husband and wife should be regulated, because the rights of a third party potentially intrude. And is Lord Phillips's are his comments really directed to that sort of situation?
They're directed, my lord, to the arrangements between the husband and wife. In many, many cases, there will be third-party interests, whether it's HMRC, could be of a smaller amount. On the way that a business is conducted in the family division is that if the third party has a proprietorial claim, actually says, as Mr. Turner said, the matrimonial home belongs to me. Often it'll be the wife's father or uncle. It really belongs to me. You can't deal with it. That is not what is being said here. We say that third parties who are mere potential creditors, not even creditors, have no lockers to come into the family division and say, do not make that order, unless there is extreme prejudice. If, for instance, in this case, the husband and wife had tried to agree an order which bypassed the worldwide freezing order, well, yes, but they didn't. They respected the wishes of the third party. And it would be, I can't think of an example of a third party, except I think for the case of Simon, which is in the bundle, and I'll come to that, where a third party who is merely a potential creditor, not even a creditor, not even having a judgment, can come into the family division and say, don't make that order. It's going to prejudice me, or I don't want it made. And we would say that Lord Phillips is dealing with the relationship between a husband and wife. And if one looks at the judgment,
Mr. Howard, I'm sorry to interrupt you, but I'm very conscious of the time and that Mr. Marks hasn't got to his feet yet, and you are the supporting act, so as to speak. How much longer?
well, I'm hoping to do it in my half an hour. That's why.
Is that what you agreed with Mr. Marks? Is it?
No, I said to your ladyship.
Oh, right,
I-
yes. All right. you just seem to be getting under steam.
Well, I may be running out of steam. Paragraph 30. Paragraph 30, page 58.
Sorry.
Delightful though it always is to have them.
Sorry, of
Paragraph
your...
30
Of the core bundle.
Oh, sorry.
Paragraph
Are we
30.
still in Radmacher?
No, I've left Ragmack in that. Sorry, I shouldn't have said.
Sorry, Granadino, you call it. So where are we?
Paragraph 30, core 58, where the learned judge represents the fundamental question. And although he says it might be potentially unfair to either or both parties in 3 lines up the bottom, one can't see why it could conceivably be unfair to the wife to endorse this order. All of paragraph 3 is about, we would say, paternalistically protecting my client. That's what it's all about. And it's, we say, inappropriate. We have not ignored the claim. It has been taken into account. Section 25 does not put a duty on a court to ascertain the debt, because it says you have regard to the obligations likely in the foreseeable future. Well, the parties did have regard to that, and we invited the court to have regard to that by the conditions. We would say that the order that we sought was not going to be made on a false basis. And all that was being sought was an order. Just, that's what was wanted. Enforcement was made quite clear, was another issue, and the bank was perfectly able to argue whether it's on an injunction variation or at the end of the trial or in bankruptcy, though that wasn't specifically mentioned, whatever they want. And we would not say that this order was an absurdity, as was suggested, I think, by my Lord Justice Dingemans. Quite often, what transpires after ancillary relief orders does render them very unfair and maybe absurd. If, say, for instance, 13 months ago, someone had owned a huge share in this Californian bank that went under, but had nevertheless agreed to borrow money to pay a lump sum, well, technically now, that man would obviously not want to keep to the order, but that's the way it is. What a family court deals with is not certainties. It deals in assessing risks, taking into account likely problems, and of course, to some extent, predicting the future. And we don't know what's going to happen in the Chancery Division, but it's not an ascertained debt. It was taken into account, and it was taken on board, and my client wants the order to be made. Section 423. Well, that was raised by Mr. Marks in his note. That's page 39. It was raised in the witness statement from Mr. Lewis. That's page 76 of the supplementary bundle. In relation to the point my Lord Justice Snowden made, I don't think that would allow the court to set aside an order, but it could certainly set aside the transfers under an order if they were for inadequate consideration, which is what the bank have been driving at here. Binding the trustee in bankruptcy.
Sorry. the order of the court. How can you not set aside an order of court but set aside a transfer made pursuant to it?
Well, I think that is certainly my experience of what is sometimes done in relation to matrimonial orders. Let's say, for instance, in order to save the wreckage, a husband agrees to transfer 100% to his wife of 1 year standing, who has a very poor claim. Then someone could come to the court and set that aside, a creditor, on the basis that there was inadequate consideration for that.
I may have misread this somewhere. I thought the effect of one of these orders was different from just the contract which underlies it. So if the order is left standing, how do you attack the underlying disposition?
Because it involves a transaction at an undervalue. Because the order enjoins the husband to make a transfer at an undervalue. I mean, that's the possible. I don't really want to argue it. I'm arguing it. But that's the sort of argument that I've seen deployed.
Successfully.
Maybe not. I don't know. I can't. But I haven't.
So I'm
maybe it
struggling
was
with
a
that
projected argument. But I mean, I don't. Our case is there's nothing in the section 423 point. But I thought, since my lord raised it, I ought to deal with it. Binding the trustee in bankruptcy or influencing the trustee in bankruptcy. Well, I don't have any instructions on that and cannot obtain them. But it wasn't raised at the court below. It wasn't argued. And all we dealt with was the worldwide freezing order. It, of course, can be raised if the matter goes back to Mr. Justice Peel, which is what the wife has suggested. My Lord, Lord Justice Snowden said, well, there's nothing wrong with waiting a bit. Well, one of the main reasons that my client is concerned is that it's not just a bit. It's a very long time, and it's got to be seen in the context of a marriage which broke down now 7 years ago. And we say that the parties are entitled to the certainty that can be achieved. There can't be total certainty, but at least to get an order that they regard between themselves as fair. 3 minutes. Obviously, I think I highlighted this. We say there's a dichotomy between the approach of Mr. Justice Peel in this case and indeed the same judge and other judges on a mounting amount of cases complaining about wasteful litigation. In fact, a recent judgment of Mr. Justice Peel described the litigation as nihilistic. If this case had not been settled by agreement, it of course has the capacity to be extremely long. And the overriding objective encourages people to settle these sort of cases. And that's what these parties have done. I think the final point I want to make is that the learned friend in paragraphs 26 and 27 of his skeleton, he effectively says that the prejudice is that the wife can make an application to vary injunction. That's really what it amounts to. Well, and that might be granted. Well, it is her right anyway, and then the bank can object. And indeed, Mr. Justice Peel, in his judgment, accepted she could make an application. So making the order doesn't stop that. If you look at paragraph 35 at page 60, third line down, in any event, H&W can apply for variations of WFO even without a consent order so as to give effect to the settlement agreement. That's what he said. And therefore, the prejudice relied upon by Mr. Marks is really no prejudice because they can do that anyway if they want. And if they do apply after an order, well, the bank can say the circumstances. They can point to the conditions that were set out in the consent order that discretion wasn't fettered. There is no prejudice in our submission. If I could just...
Of course.
No. Unless there's anything else I can assist.
Thank you very much indeed, Mr. Hunt. Yes, Mr. Marks.
Just going to play dance the lectern for a moment.
Certainly, of course.
My lady, my lords, my learned friend Mr. Turner and my learned friend Mr. Howard have spent now about 3 hours explaining why Mr. Justice Peel could, they say, have approved this order. What they've not even scratched the surface on is why he had to. And the true question in this appeal is whether section 33A, which of the matrimonial cause act, which I'm going to take court to in just a moment, is so limited that even if the judge to whom a consent order is presented considers it necessary to establish some further matter, he must make the order rather than adjourn to have that matter established by other things going on. I'm going to start, if I may, with section 33A, which is in the supplemental bundle at tab 22, I think, page 387. Just to put this in context, section 33A was inserted into the Matrimonial Causes Act to enable the court to approve financial orders between separating and divorcing spouses as boxwork without requiring the matter to be canvassed and ventilated in court. And so what we have is section 33A, notwithstanding anything in the preceding provisions of this part of the Act, on an application for a consent order for financial relief, the court may, unless it has reason to think that there are other circumstances in which it ought to inquire, make an order in the terms agreed on the basis only of the prescribed information furnished with the application. So that is a permissive statute enabling and empowering the court to take at face value what it's told, in either on paper or in submissions, and decide whether to make an order. But it has the let out, firstly, that it doesn't have to, even if there isn't some other matter it feels it should inquire into. It may, unless it has reason to think there are other circumstances in which it ought to inquire. And that's all that Mr. Justice Peel has done. He's asked to make a consent order. He's of the view that it's necessary to inquire further into whether the husband has a $4 billion plus liability to my client, the bank, because he thinks that that's a necessary part of the inquiry as to whether he should approve the order. And nothing that my learned friend Mr. Turner has said, nothing that my learned friend Mr. Howard has said, disapplies that discretion which was exercised by Mr. Justice Peel. We've already seen the part of the judgment where he said if this was an early stage in the proceedings would, he said, surely have been stayed to await the outcome of the trial. So the matter into which he wishes to inquire is whether there's a liability of $4 billion or whatever it happens to be, and the way he proposes to inquire into that is to wait until Mr. Justice Trower has decided that question in a trial which is now less than 3 months away from its commencement. He was thereby doing no more and no less than this court, Lord Justice Thorpe's judgment in the case of George, said should be done if there's an uncertainty with some outstanding litigation. Mr. Howard says, oh, well, that's different because that was contested proceedings. But these aren't contested proceedings, this is a consent order. Well, section 33A is about consent orders, a matter into which Mr. Justice Peel felt there should be inquiry. That inquiry is going to be carried out by Mr. Justice Trower. And to suggest that by doing that, by adjourning consideration of whether to approve the consent order, Mr. Justice Peel was going out with the discretion vested in him by section 33A, we say, is absolutely unsustainable.
Well, he certainly wasn't going outside the discretion. The question is whether he was exercising it on the right principles.
Well, my lord, yes, I accept that. Was he exercising on the right principles? He sets out in his judgment that he felt that he needed to be able to compute the assets at least to the nearest $4 billion. And he felt that he couldn't do that. He described the husband's disclosure as being in any event unreliable, assets being in Ukraine. He wasn't able to say what the total value of the assets was, even before we reached the stage of considering whether there's a $4 billion liability. But his main concern was that he didn't know whether there was a $4 billion liability. And although here, Mr. Turner has, my own friend Mr. Turner, has been seeking to preserve the position that the wife's claims may survive that, in his skeleton argument to paragraphs 18 and 27, he concedes that if the bank is substantially successful in its claim and the wife has not by then got an order, there's not going to be anything left for her to make an application against. Now, that may not be true, of course, because the bank could be successful but not wholly successful. It may be that there's going to be some residue against which the wife can make her claims. But we do say that Mr. Justice Peel, in his judgment, is very clear that the reason that he's not yet prepared to approve this order, he hasn't said he won't approve it, he's just said he won't approve it yet, is because he wants to know the extent of the husband's liability to the bank. Now, in our respectful submission, that absence of error on behalf of Mr. Justice Peel is, without consideration of the special facts of this case, sufficient to dispose of the appeal. We say that on general principles relating to case management decisions, which we say this was, it's an adjournment, case management decision, and the considerations under section 33A of the Matrimonial Causes Act, no sufficient error has been shown on behalf by Mr. Justice Peel to warrant this court's interference. Beyond that, we say on the specific fact of this case that there is an uncertainty of plus or minus over $4 billion in the total value of the assets. That too, as a special fact, would be sufficient to justify the making of the order that Mr. Justice Peel did, namely to adjourn consideration of the wife's claims. A third layer, which relates not to that individual specific fact, but to some of the other specific facts of this case, which raise an index of suspicion, starting, of course, with the nature of the allegations against the husband in the Chancery proceedings, the allegation that he's a fraudster, all the way through to what Mr. Mr. Turner candidly admitted to be the husband's motivation in agreeing to these terms, which was he would rather his wife and the children had these assets than the bank. So we have what we would suggest is at the very least, and perhaps it's an answer to my Lord Justice Snowden's question, but why would a husband agree to this sort of order? The answer is, as a way to preserve for the benefit of his family what we've described as the low-hanging fruit, the only assets in the jurisdiction, the assets which may or may not be accessible in the Channel Islands. And the idea is to scoop them up, take them out of the pot that's available for a claim by the bank. And quite clearly, the plan was, maybe still is, to go to the Chancery Division armed with an order, assuming that an appeal is allowed, the case is remitted to Mr. Justice Peel. Mr. Justice Peel makes an order in substantially the terms sought. The plan is to go to the Chancery Division, although Mr. Turner said in his submissions that it wasn't. Page 35 of the, I think it must be the supplemental bundle. Page 35 of the supplemental bundle is the letter which accompanied the wife's application to the court for a listing of the application for the court to approve her order. So starts at page 34, on the 7th of December 2021, for the attention of the FRC manager, identifying counsel, over the page to 35, right in the middle of the page, the parties have always accepted that the financial consent order now sought will be subject to the variation or discharge of the second worldwide freezing order, and 2, upon the making of such a financial consent order, the respondent will apply in the commercial court for an order varying the terms of the second worldwide freezing order to enable him to discharge his obligations under the separation agreement as approved by the family court in the financial consent order. It was clearly advertised that that was her intention, and until today it hadn't occurred to us that the wife had backtracked on the idea that that was what she was expecting to happen. It's true that that says that it would be for the husband to apply, and so maybe it's not the wife's intention that matters, but the husband's intention. Now, there are a raft of issues which have arisen in this case, which are not the subject of an appeal. Our standing in these proceedings, we applied to intervene, we were allowed to be heard, our application to intervene was granted for so long as it took for us to be heard, and then we were unjoined, no longer interveners. We haven't appealed against that. We applied for a stay of the proceedings. We didn't get a stay of the proceedings. We haven't appealed against that. And we applied for inspection of documents, and we didn't get that either, and we haven't appealed against that either. We did, though, achieve what we really wanted to achieve, which was a delay, a postponement of the approval of the order to be made on the wife's claims. Now, the consequence of that, one of the consequences of that, has been that our understanding of the underlying background to this appeal, to the application for the consent order, has been evolving. We made a point in our skeleton argument that there were documents that we hadn't seen. We hadn't even seen the order that the parties were asking the court to make. We hadn't seen the wife's witness statement. We still haven't seen any of the exhibits or attachments to her witness statement, even though we have asked for them, and I'm going to come to that in a moment. We hadn't seen the D81, which is the document that the parties fill out. They have to sign it and declare that it's a true statement, and it's presented to the court when seeking a consent order. Now, we've been, as a result of my lady's intervention this morning, we have now been provided with a copy of that document. I don't know if the copies have been handed up.
They have. I don't think any of us have had an opportunity of looking at them.
No, and we received ours at about 10 to 2 or thereabouts. And we see that for the first time. And just before I invite the court to that document, might I invite attention to the wife's witness statement, which is one of the documents that we had not seen at the time of the hearing in front of Mr. Justice Peel. We received it on the 1st of February of this year with, as part of the supplemental bundle. And if I may, I'll take the court to page 87. And we learn a number of things from page 87. At the very top, paragraph 55, we learned, the last sentence of that paragraph, between October 2017 and December 2017, husband transferred to me approximately £7 million, being $5 million US on the 6th of October, £1 million on the 27th of October, and $3 million US on the 6th of December for this purpose. And she then sets out in the next paragraph renting and then buying a property. Then she deals with the children being at school. And then in 58, she says something about one of the children coming back to school. And then she says this: I have approximately £4 million remaining, but this has to fund school fees, mortgage repayments, travel, staff, legal fees, food, utilities, etc. I have no other financial resources pending implementation of the February 2017 separation agreement. Shortly before the short adjournment, my Lord Justice Dingemans asked my learned friend, responded to an observation by my learned friend, Mr. Turner, about what becomes of the wife if the husband is wiped out by the bank's claims. And my Lord Justice Dingemans said, well, she'll be like every other wife of a destitute husband. Well, now that we've got the D81, we can see that that is very, very far from the truth. If I could take the court to what is internal page 6 of the D81.
Sorry, just give me a moment. I seem to have do I seem to be able to find a statement of costs?
Quite a chunky document, my lady.
Got it. I think I've tucked it away for future reference, and I can't find it now. Got it. Thank you. Thanks, James. Sorry about that.
Page 6, my lady.
Thank you.
Remembering that paragraph of her witness statement, which was prepared for the purposes of securing the approval of the consent order, I have approximately £4 million, but this has to fund school fees, mortgage repayments, etc. We have this page, which are the notes to the disclosure document, and we see what she actually has. She has a property in Stade, purchased for £10.5 million with a mortgage of about half of that. She has an apartment in Vienna, purchased for about £2.5 million with a mortgage of £1.6 million. She has in Switzerland, at UBP Switzerland, she has about, totting those up, about £3.4 million. In Cyprus, £7.3 million. In Austria, 850-odd thousand. Czech Republic, 700,000. Winterbank, Austria, 840,000. 560,000 here. Portfolio, Cyprus, 2.37 million. Got some artwork. She has jewellery worth £4 million. She has corporate assets in Turkey worth £4 million. She has some assets in Ukraine, doesn't ascribe a value to them, and she has some liabilities, and tops all that up together, and it comes to about £32 million. Oh, but there's some liabilities. So there's a Lombard facility. I'm not absolutely sure what that relates to, but being fair and netting that off, she's down to about £25 million. So how does she come to say in her witness statement that she is down to her last £4 million? Well, perhaps that wouldn't much matter if this was not a case in which the background is of a vast fraud and in which we say it is perfectly obvious that what the husband and the wife are seeking to do by agreement is to disqualify Mr. Justice Peel from examining whether the right award is what is set out in the consent order or whether it is something else. And they seek to do that by telling him, oh, the parties are agreed, they've had very lengthy, detailed negotiations, this is what they've come to. Mr. Howard's going to say, oh, my client will take all the risk of what is going to happen in the litigation. In other words, what they're going to do is they are going to manoeuvre the court into the position where it has, they hope, no choice but to approve an order giving the wife not the £100 million that my learned friend Mr. Turner has suggested, much closer to £200 million. And I'm going to come to that in a moment. So, is the court entitled in considering whether it's going to approve an order, entitled to take into account scepticism, if it has it, as to the motivation for the making of the order? Well, my learned friend Mr. Turner, in the course of his submissions, referred to there being a legitimate agreement between the parties. We had canvassed with Mr. Justice Peel our suspicions. They were then quite hazy submissions, quite difficult submissions for us to develop, that this was not all that it appeared. And one of the points that we made was that we were aware that there had been a prenuptial agreement. Hadn't seen the prenuptial agreement. We'd asked to see the prenuptial agreement. We'd been refused sight of the prenuptial agreement. It was one of the documents that we asked Mr. Justice Peel to let us see, and at the end of his judgment he dismissed our application to do that. However, In the course of his judgment, he told us what was in the prenuptial agreement because he had seen it. And he sets it out in paragraph 6 of his judgment. Now, this was the result, this prenuptial agreement was the result of negotiations between the parties through their solicitors. Mr. Harper, who still acts on behalf of the husband, and Mr. Stewart, who at the time was acting for the wife. Anyway, what were the terms of the premarital agreement? Well, they're set out on page 54 of bundle tab 7, page 54, paragraph 6. On the 10th of March 2011, they entered into a premarital agreement, under the terms of which the wife would receive upon separation £1 million, £2 million for each year of the marriage. It lasted 5 years, so that'd be £10 million. £500,000 per annum for life, and 20 million in trust as a housing fund. And the husband's wealth was recorded in the premarital agreement as £3 billion. Now, the court has heard much from both Mr. Turner, particularly from Mr. Howard, about how an agreement between the spouses is presumptively determinative of the appropriate outcome of a financial remedy claim. Radmacher says if they've agreed it, it's paternalistic of the court to impose some different value. And what's more, he says, well, then, if there hasn't been fraud, there hasn't been duress, there hasn't been some misrepresentation, then the court would be bound to make, effectively, would be bound to make an order in those terms. That's the situation.
I don't want to interrupt your flow on this because you've advertised at this point in your skeleton argument.
Yes.
But I do notice that this, the prenup was dated the 10th of March 2011.
Yes.
At which stage there'd been a child born in 0709.
Yes.
One born in 2010, don't know quite when, so baby still.
Yes.
And one child
Yes.
yet to be born.
Yes.
I mean, go back to paragraph 75 of Radmacher.
I'm just coming to the changes, my lady.
I think one has to be careful how much weight, because would this have been approved from a man by the court under 33A?
Oh, well, my
If
lady. We say it undoubtedly would have been, but I'm just coming to the
It's a
question.
fair outcome for a man worth £3 billion?
Well, my lady, we're going to just come to the changes and what the parties say about it. Because had it been the case that the parties had agreed that that agreement had been entered into in circumstances of unfairness, I've already told your ladyship who the lawyers were. They negotiated this, they reached agreement, they embodied it in a document which we haven't seen, but one could imagine is going to contain all of the usual formalities necessary to make it look watertight. And then one does have to reflect on what it provides her with. £11 million, £20 million in trust as a housing fund, and £500,000 a year for life. Mr. Turner said this morning that the wife acknowledges that the husband's wealth was generated before the start of their relationship, and that's why, implicitly, her claims are going to be determined on the basis of needs rather than on the basis of sharing. But what the draft order says, which we hadn't seen at the time of the hearing in front of Mr. Justice Peel, and what her witness statement says, which we hadn't seen at the time of the hearing in front of Mr. Justice Peel, is not that there was anything wrong with this agreement at the time that it was entered into, but that in the changed circumstances, they had come to regard it as unfair. I can take your ladyship to the specific parts of the just one moment. 110 of the supplemental bundle.
We have got the witness statement where at paragraph 36 onwards, the wife rightly, this would be, you've got to be careful not to try and start making findings of fact here, but the wife was very clear that she was not happy with the prenup.
she was unhappy. It doesn't suggest it was vitiated by that, by the circumstances which it was entered into. And the order itself, at paragraph 100, at page 110, paragraph 20 of the order, the draft order that we hadn't seen, in entering into the separation agreement, both parties acknowledged the terms of the premarital agreement were by that time no longer fair or appropriate. So plainly hanging that on a change in circumstances. And the wife, in her witness statement, says much the same thing. She says, just after the period that your ladyship just referred me to,
I understood he wouldn't go through the marriage in the absence of the agreement. However, the terms of the prenuptial cause significant and long-standing issues in our relationship.
yes, so she was unhappy with it, as many people are once they've signed up to a prenuptial agreement, even one that gives them £20 million of housing, £11 million lump sum, and £500,000 a
Well,
year.
you know, we it's all in context, isn't it?
Of course it is, my lady.
When their running costs were over £2 million a year, their
I-
household running costs.
I accept, my lady, that she might have asked for a little more. We're going to come to how much more she, in fact, seems to have bargained for.
But where is this taking us?
My lady, where it's taking us to is the proposition, which I'm about to advance, that the only relevant change in circumstances between the date of the prenuptial agreement and the date of the agreement which the parties are now asking the court to take into account is that the husband found himself at the eye of a storm of litigation. There were two other changes. One of them was that they had a fourth child, and your ladyship has already referred to that, and I accept that in some cases the arrival of another child might be such as to move the margins of the kind of award which would be appropriate. But in my respectful submission, a fourth child in circumstances where the provision was already at that sort of level is not a prenuptial agreement invalidating kind of change. Now, there had also been a change of £2 billion in the husband's wealth, but it had gone down from 3 billion to 1 billion. We collect this from the judgment of Mr. Justice Peel. We did not know that until he told us in the judgment that we received after the hearing. And a reduction in the husband's wealth by 2/3 realistically cannot be the trigger for the parties feeling the need to renegotiate a prenuptial agreement upwards by, as I'm going to suggest, a factor of 5, 6, 7, as well as greatly improving the nature of the provisions that are made for the wife, which is to have many of the assets outright rather than bulk on trust, and also that it was effectively excluding the husband from all of the UK and Channel Islands based assets.
Mr. Marks, may I ask a question, if that's all right? I mean, the bank's not going to accept the original prenup amount, is it?
Well, my lord...
Or is it?
Well, my lord, what I would say is if the parties had come to court seeking an order in the amount of the prenuptial agreement, I think that the bank would have found itself in difficulties saying the court should not approve that order. Because that entitlement could be argued to have been crystallised in 2011, which is before the commencement of the fraud against the bank. And whilst many of our other points would still be good points, we would not have been able to suggest that the provision for the wife was being agreed specifically to defeat our claims. It was not targeted at the UK assets. It wasn't targeted at specific assets at all, in fact. As far as we can tell, we haven't seen the prenuptial agreement, but the summary that we've seen of it doesn't suggest it was targeted at specific assets. And we probably would not have been able to resist the making of the order. We would still have resisted the freezing order being varied, and we would still have sought to compete with the terms of that order in any subsequent insolvency proceedings. But I don't think we would have been saying that the court shouldn't have made that order. Of course, even if we hadn't intervened, it could have been that Mr. Justice Peel, being presented with that, might have said, yes, but if there's this $4 billion liability, can I think that the husband could meet these terms? Should I give my imprimatur to this award of the prenuptial agreement? But we don't know. We wouldn't have been there.
But you say you wouldn't have opposed him.
I don't think we could have opposed the making of the order. Whether we, as I say, we might have well sought competition in terms of enforcement, but we would not, I think, have resisted the making of an order.
What do you mean competition in terms of enforcement?
Well, because once the order had been made, assuming that we had resisted the wife's attempts to unfreeze assets from the worldwide freezing order, we would have resisted that. We would have said that she should wait. There's been an order, just as we would say if Mr. Justice Peel's order in the terms now being sought had been made. We would not have rolled over on an application to the Chancery Court to vary the worldwide freezing order.
Sorry, I thought you finished.
No.
How could you resist it? Because you get no priority with the freezing order, and if there's an agreed debt between two parties, you can't just stand there and say, "Oh well, keep them to the terms of the freezing order."
Well,
if I can engage in a judicial one too, because I was about to ask the same question. I mean, the whole point of a freezing order is not to preserve a fund, other than against improper disposition.
yes.
And this would not be an improper disposition.
Well,
as my lord said, this would be an order which had been approved by the court.
Well, I now find myself in a position of saying, well, that's exactly what we fear from Mr. Justice Peel making the order that the parties are now inviting him to make.
But the en route, you said you would have resisted
Well,
the compliance with the order if it had been made, but wouldn't have resisted the order being made. And I'm struggling for myself to follow the logic of that.
well, my lord, it's a hypothetical. We weren't presented with the question, would you consent to us making an order in terms of the prenup? If we had been asked that question, I'm speculating that the advice that we would have given would have been, it's a pre-existing prenuptial agreement. On the face of it, it's a proper order to be made. I don't know where that would lead.
Notwithstanding that your client's claim would, if successful, much outweigh by many times the amount of that consent order, and you wouldn't, by the sound of it, you wouldn't be contending that the order should take second priority to the payment of debts by one of the two parties to the marriage.
Well, my lord, I think I can most honestly say that this is not a hypothetical with which we previously wrestled, and I suspect that what our position would have been is that she only gets the property on trust, which implies that it reverts at some later stage to the husband's estate, and we would scoop that up at that stage. We may have to wait whilst the wife had the use of the property that was provided for her. The periodical payments, we would probably have argued, once we've got judgment and the husband is bankrupt, they are variable, so he will be paying less. There's no periodical payments in the proposed order, but if he's been made bankrupt, we would be, a trustee in bankruptcy would be saying that the periodical payments order should be varied downwards. And the lump sum is £11 million. Well, as you've heard, as we found out very recently, the husband's already paid £7 million. We wonder where the rest of the wife's assets came from, but he's already paid 7 of what would be 11. Would we be standing in the way of release of £4 million? Well, my lord, I don't know. Probably. We probably would have been, because it's that kind of litigation. But the scale of the difficulty, the scale of the issue between the parties, if the parties had agreed to the premarital agreement rather than the 2017 agreement, would obviously have been an order of magnitude different. Mr. Turner, in the course of his submission, suggested that the value of the provision to the wife is about £100 million. It's very far from that. It's closer to £200 million. I'm just going to, if I may, just fill in a little of what's missing in Malone and Friend Mr. Turner's analysis.
So, just so I've understood, you don't say, therefore, that debts to third parties necessarily come off the top before the court ought to make a consent order in matrimonial proceedings?
I don't say they necessarily come off the top, although I would say conventionally they would come off the top, and there's nothing wrong with assuming that they're going to come off the top. If you're the trial judge, you're perfectly entitled to say, I need to know whether there's a liability here so that I can decide how it factors into my thinking. Our submission below was that the judge needed to know whether there was a $4 billion liability before he could approve the order that he was being asked to approve, partly because the terms of that order had been agreed between the husband and the wife without any prior basis for that negotiation, by which I mean only in the light of the impending litigation. And whilst the conventional method is to take the liabilities off the top and to work with the net assets, there may be circumstances, as both Malone and Friends have said, there may be circumstances in which a couple are able to say to the court, well, yes, there is this big uncertainty, and it may be my assets are going to be wiped out, but this amount can be fairly ordered to the wife because, and in this case, it would be because we had this fiercely negotiated prenuptial agreement in 2011, which is before this fraud was alleged. I can demonstrate that some of the assets at least predate the fraud, and I should be able to, husband would say, I should be able to meet my obligations to the wife, having regard to the prenuptial agreement we entered into, even before it's alleged I was involved in fraudulent behaviour. And the judge could take a view. And if the judge had taken the view that he wasn't going to make the order, well, he wasn't going to make the order. Or he might have taken the view that he was going to make the order. But that's not what he was confronted with. He was confronted with the fact that he mentions in the judgment the amount of the prenuptial agreement, which he knew we didn't know. The fact that he refused to redact that when Malone and Friends asked him to redact it when he sent out the draft judgment, tends to suggest that it was in his mind that the unexplained difference between what's in the prenuptial agreement and what's in the 2017 agreement was something into which, again, it might be necessary to inquire. There is a certain amount of mystery about the extent of the provision that's to be made for the wife under the agreement, but we think that it is at least this, at least 120 million in terms of loans that are owed by the trust to either the husband or companies on his behalf. At least 120 million. That happens to be the figure in the D81. Then there's the question of the remaining assets, the surplus assets in the trust, after those loans have been repaid. Well, we can't be absolutely sure what they are. It's suggested in the D81 that they're only 20 million. We think that they're at least 32 million. Wife also gets a lump sum of £10 million, and seemingly, although she's had £7 million, no account is taken of that. Now that we've seen the draft order, we can see that although it records that she's had £7 million, that's not said to come off the £10 million. We don't understand why not. So one tops all of those up together, and we come to about £171 million or so. Now, of course, that does depend upon the properties achieving what they're said to be worth, but one has to take those things more or less at face value. And what we learnt today is that in addition to all of that, she's already got 25 million net of other expenses. So what was it that gave rise to that change in heart by the husband between 2011, where he fiercely negotiated a prenuptial agreement that would have given her that which Mr. Justice Peel sets out in paragraph 6 of his judgment, and 2017, well, we've been through that, birth of the child, £2 billion pounds reduction in his fortune, and then there's the impending storm of litigation. And we know what the impending storm was. Learned from Mr. Turner has mentioned there were 3 sets of litigation. Tatneft started in 2016, eventually dismissed on the basis of limitation period. The Russian limitation period had expired, and so that application was dismissed. The Schulman litigation commenced in May 2017, eventually dismissed on the grounds that there was no sufficient jurisdictional connection between the husband as defendant and the other defendants and this jurisdiction. That was commenced in May 2017. And then there's these proceedings, I say these, the bank's proceedings, started in December 2017. At first instance, dismissed for want of jurisdiction, but reinstated by this court, which overturned the decision of Mr. Justice Fancourt dismissing the proceedings for want of jurisdiction and holding that he had been wrong to say that he would have stayed the proceedings had he not struck them out for want of jurisdiction. Now, we'd known all along that the husband had moved to Switzerland to try to break his connection with this jurisdiction. Moved in early 2016. The wife says that was the cause of the breakdown of the marriage. And she confirms what we knew from other judgments in the proceedings, that he had left this jurisdiction specifically to not be an anchor defendant for litigation in this country. And we now know from her witness statement that that is why she too moved to Switzerland, not at the same time. She said they separated because he was moving to Switzerland and she wasn't going to go. But she says, in September 2017, he told me I had to leave the country, so because otherwise I could be used as a way of keeping him within the jurisdiction. So she says that for that reason I left. We didn't know that. We didn't know that the reason that she left was in order to assist him in evading English justice. What proceedings did he have in mind in September 2017 when he said that to her? Well, it can't have been Tatneft because they were already underway. Can't have been Schulman because that was already underway. The only proceedings which were about to hit him were our proceedings, which came along 3 months later. And we say that it is perfectly obvious that this couple have engaged in a strategy to try and avoid husband's liability to the bank in the proceedings which are now running in the Chancery Division, are going to be tried next June. And we say that the strategy that they adopted included agreeing this new agreement in 2016, formalised in February 2017, was all part of a strategy to make the husband as judgment-proof as was possible for them. We say that the court is entitled to be sceptical about things that are said by parties in circumstances where it is obvious. We say now say it's obvious because of what we've learned since the hearing in front of Mr. Justice Peel, obvious that the strategy is to make the family wealth inaccessible, insofar as possible, inaccessible. Now, we don't know, we don't actually assert that Mr. Justice Peel had all that in his mind. He almost certainly hadn't been able to do the analysis of the wife's witness statement that we've been able to do. But it is a further reason why he was right to consider that it would not be right to approve this order until the husband's liability to the bank has been established in the Chancery proceedings. And that, we say, is a further reason why this court should not interfere with Mr. Justice Peel's decision. one of the factors that my learned friend Mr. Howard in particular has prayed in aid is that the 2017 agreement is said to have been carefully negotiated.
One thing, could you just remind me when you say you've got all the various documents, just obviously there's no respondent's notice.
There's no response notice because we didn't have the documents until, your ladyship will recall that in our skeleton argument,
Yes.
we made the point that the reliance had been placed by Mr. Turner on documents that we hadn't seen, and we said that's not on. And I think your ladyship made an order or had a letter sent out that said there'll have to be a proper application if there's documents to be withheld. We weren't ever told what was going to happen, but no application was made. And then the supplemental bundles were delivered, were delivered on the 1st of February. And that's when, for the first time, our skeleton argument having gone in, I think, in December, that's when we saw for the first time two crucial documents, the wife's statement and the draft order. Now, the wife's statement refers to the prenuptial agreement. It exhibits the prenuptial agreement, but the exhibits are not included in the bundle. We wrote, pursuant to CPR 3114, asking for inspection of, and if appropriate, a copy of, a document referred to in a witness statement, which we're entitled to. We asked for that, we were refused. We repeated our request, we were refused again. And we would certainly be, in those circumstances, a document we're plainly entitled to see, we would respectfully submit that one can draw the inference that the wife doesn't want to see it because it shows things that would be supportive of our case rather than of hers. And I've already shown you one inconsistency that we've learned today between her witness statement and the contents of the D81. I can't remember whether we also asked to see the D81. I don't think we did, because I don't think it was referred to in her witness statement. But we do say that the contents of the prenuptial agreement is potentially highly relevant. Now, Mr. Justice Peel had seen that document, and he refers to it in his judgment. We haven't seen it. Your Ladyship was asking me about dates. So what have we seen? We've not seen the prenuptial agreement, but we have seen the order, we have seen the wife's witness statement, and today we have seen the D81. And each of those documents, each time we've received a new document, it's cast new light on what we know about the case. And to see in particular that the wife was deposing to have assets of £25 million net in the D81, whilst in her witness statement saying that she had £4 million, which was dwindling fast, we say tends to show that there hasn't been quite the careful consideration given to telling the whole truth in her witness statement that there should have been. There's an oddity in this case, which is the two oddities, and they both relate to the ease with which the husband has rolled over. And the first, I mean, my lady...
Can I just ask, just before you sort of start on the next round of jury points, can I just... I'm just struggling to understand, interesting though it's been to listen to it, what you want us to do with the last 20 minutes.
I submit that Mr. Justice Peel's judgment, as well as the core underlying reasons that he gives, can be read as nuanced by what he knew, but that we didn't know, as being a further reason why he should be sceptical of the motivation of the parties in seeking the agreement, and to have the agreement turned into an order. It's perfectly obvious why they want it turned into an order. It gives the High Court's imprimatur on this being the value of the wife's claim. Your Lordship was asking me earlier about, well, what would you have said about the prenuptial agreement? Well, the value of her claim at the time they separated was the value of that prenuptial agreement. And the fact that they have negotiated it, apparently, they have negotiated that up to embrace all of the UK assets, which we say is something else that Mr. Justice Peel would have been entitled to take into account if we'd been able to articulate it to him, which we weren't. All we were able to say at that time was that we were deeply suspicious of the parties' motivations and that the court should be cautious before making an order in terms of an agreed been agreed between parties against as much uncertainty as there was in this case. And whilst I entirely accept my Lord's rebuke that in some ways these have been dual points, I think I've got broad enough back to accept that challenge to what I've been saying. Nonetheless, neither Mr. Justice Peel nor this court need to leave behind worldly wisdom and a healthy degree of scepticism about the question that my Lord asked my learned friend Mr. Turner: why would a husband do this? Why would a husband expose himself in this way? Why would a husband who has a prenuptial agreement negotiated 5 years earlier, in what seems to be more or less the blink of an eye, say, I'm going to give that up? And I've represented a lot of husbands over the years.
Yes, I think the context of the question was slightly different, as I recall it.
It was.
The context was why is there not, or is it was all to do with the facility to vary or review this order rather than anything else. But so the context was different, I think.
Yes, it was why would he put him in the position that when he ended up with zero after enforcement by the bank, if that was the outcome, why would he put himself at risk in such a way?
Great respect, it's all part of the same question. Why would he have agreed to any of this? Of course, it does expose him to that risk of ending up with zero. Mr. Howard says, but he's a grown-up, he's an entrepreneur, he's willing to take that risk. Why is he willing to take that risk? The reason he's willing to take that risk is, as Mr. Turner said, he would rather his wife and children had it than that we had it. And so instead of the money being returned to I say returned to, that makes it sound like a proprietorial claim, being made available to satisfy a damages claim to reimburse the Ukrainian savers who've been bailed out by the Ukrainian government, themselves financed by the IMF in the wake of this fraud. Instead, it's going to go to the wife and the children. That's the plan. And we do say that it is surprising that a husband would agree to something which left him so vulnerable, my Lord's point, but also surprising that a husband would, having negotiated a prenuptial agreement without putting up any sort of resistance at all in 2016-17, agree to pay her, we say, at least 5 times more than she was getting under the prenuptial agreement. Experience tells us that if that's going to happen, it normally happens after a bit of a struggle, not as easily as it appears to have happened here. And why is he so desperate still for an order to be made? Why is Mr. Howard here supporting the wife? Your Lordship's question, why would a husband do that? And the only plausible reason is that to defeat bank's claims, he wants to have an order that the wife can put up as a prior claim to the assets, because it's perfectly clear that it is the plan that she would go to the court, the Chancery Court, and ask for a release of the worldwide freezing order. We floated in front of Mr. Justice Peel the possibility of a genuinely conditional order. A conditional order, not that enforcement was conditional, but that the order was made in terms which were expressed to expire. The order would be automatically set aside and vitiated in the event of a judgment against the husband in excess of insert figure. We canvass that as being a possibility if the judge was against us on not making an order at all because of the uncertainty, and he was determined he was going to make an order, decided that Radmacher meant that he ought to give autonomy to the party's decision. He could have made an order, we conceded, that was in its own terms conditional. Rather than enforcement being conditional, the order itself was conditional. We said that's very much second best, because you're not in a position to, we say, you're not in a position to know whether this order is overly generous. It's unlikely to be too mean, but he was unable to tell what the overall assets were, and so he shouldn't do it. But if the order exploded, self-destructed, in the event of a substantial judgment, again, we could probably have lived with that, so long as, of course, she wouldn't be able to. The wife wasn't going to take it off and try and get it implemented before the judgment in its terms. It would obviously say that she couldn't do that. And so there were ways in which Mr. Justice Peel might have made an order in the wife's favour, notwithstanding the uncertainty, to adopt what my learned friend Mr. Turner and Mr. Howard have said. He could have made an order in whatever terms, including the terms that the parties had agreed, but say, in terms in the order, not she can only enforce it if, but this order will only stand if the bank's proceedings are dismissed or substantially unsuccessful, maybe set a figure limit as to the amount of damages which would justify the order remaining in place or self-destructing. And that, had there been a genuinely conditional order, again, that might have been a solution to the case, but he wasn't. Mr. Justice Peel wasn't presented with that. Mr. Turner and Mr. Howard didn't want that. They didn't want to put forward some alternatives that were based on having actual conditions as to the order. And we say that that, again, is because the whole plan is to get High Court Judge, Mr. Justice Peel, to approve the terms of their agreement, which have been reached in the way which we have indicated. We had said to Mr. Justice Peel that it wasn't necessary for us to assert a deliberate plot between the husband and the wife to secure something from the financial wreckage, but that each of them must surely have been motivated by that in agreeing what they agreed and in seeking to have the order made in the circumstances in which they sought to have it made. But to return to where we are now is that no proper error has been identified in respect of Mr. Justice Peel's decision. And what's said is, particularly by Mr. Turner, but he's echoed in this by Mr. Howard, is that the wife suffers terrible prejudice by the order not being made, and the bank suffers none by it being made. And the main prejudice that Mr. Turner, on behalf of the wife, says the wife will suffer is the possibility of the husband's death. And this was a submission he made below. And of course we recognise the possibility that the husband will die. But Mr. Justice Peel deals with this in terms in paragraph 39 of the judgment on page 60. Beginning of paragraph 39, the wife submits that the consent order should be made because she cannot otherwise claim against the husband's estate in the event of his death. Sets out the basis of that. And then after the reference to the leapfrog appeal in Hassan and Al-Hassan, judgment in which has been reserved, so the Supreme Court has not yet delivered itself to judgment in that, I reject this submission. This case, as between the husband and wife, is proceeding consensually. It's open to the husband to execute a will so as to make provision for the wife. That may require expertise in both Ukraine and this jurisdiction to assist H, but I've seen nothing to suggest it can't be done. And then some key words. The separation agreement itself at clause 10.1 records a covenant by the husband to make provision for the wife and the children by will within 6 weeks of the date of the agreement. The agreement was the 20th of February 2017. In terms no less generous than those set out in the agreement. It's not even clear, and certainly not expressly stated on behalf of the husband, that there is no such will in existence, nor, if it has not been done, is there any explanation why not. I'm not satisfied that, if it be the case that there is no appropriate testamentary provision in place, his failure to comply with the term of the separation agreement could in itself, be a reason for not making of a consent order, which in turn reflects the separation agreement. So, in the separation agreement, he was to make a will. We're not told he hasn't made a will, so the whole of the spectre raised by my learned friend Mr. Turner about the dire predicament of his client, were the husband to die, which I acknowledge he could, is, in my respectful submission, wholly illusory. And my learned friend Mr. Howard characterises our case in relation to the prejudice that the bank suffers by the making of the order as being simply, oh, well, the wife might make an application to discharge the freezing order and we'd have to deal with that. We've actually dealt in page 43, paragraphs 26, 27 and 28 with the prejudice the bank suffers. Yes, we face the prospect of an application to discharge the freezing order. Much worse than that, we run the risk that that application is successful for the very reasons that my Lord Justice Snowden was suggesting we might have faced if there had been an order made in the terms of the prenuptial agreement, which is to say, once Mr. Justice Peel has approved it, what answer do we have to the variation of the freezing order? And the answer is, not much. We might have arguments, not really my field, but one can see that the strength of the case would be Mr. Justice Peel has agreed this, he's approved this, he's decided this is the value of my claims. Of course, because the only basis upon which he's approving it is that the husband and wife have agreed it, the reality is he would just be saying, well, this doesn't look too bad to me if there isn't the $4 billion liability. He isn't in a position, as he said, to approve the order in the normal circumstances, which he knows what the value of the pot is. But the third way in which we will be prejudiced...
Well, it's not that he... you're not quite right in that last bit, are you? He knows the value of the pot.
Yes.
He doesn't know the value of the claims against it. Because you accepted earlier on that, in fact, in principle, an order could be made which, as it were, bit into the gross pot. In other words, that you accepted that the bank doesn't automatically come first.
Doesn't automatically come first. It may be a matter of degree.
So what's not known, the critical question, is in fact is the extent of claims against property which might be covered by an order under the Act,
Yes.
Matrimonial Act.
That's a better way of putting it than the way I put it. Your Lordship canvassed earlier on two pots. There's the general pot against which all claims are made, and there might be a different pot against which the bank's claims are not good, but the wife might still have claims.
Well,
So,
yeah, I mean, I may be completely wrong on that. I'm beginning to think I might well be wrong on that. That if it were accepted as a matter of principle that third parties have to be paid before there's a division, and that is some form of rule, principle to be derived from the authorities, then in essence you are talking about two funds, two different pots.
yes.
But in fact, I think your earlier exposition of what your attitude to an application based upon the prenuptial agreement suggests that analysis isn't actually right. My analysis isn't right.
Well, my Lord, there's a special fact which is why it doesn't invalidate that analysis, and that is that there are trust assets which may be invulnerable in bankruptcy. I don't know whether the trust assets. An application has been made. We advertised in our Snowden argument. We said that one was being considered. One has now been made. An application has been made to set aside the dispositions into the trusts. Now, that may or may not be successful. If it's not successful, there will be assets in the trusts, not the loans which have come out of the trust, but the remaining assets in the trust. If those trusts are not set aside, then the bank is going to have a difficult argument to say it can enforce against those trusts. The wife, though, has quite a good argument for her, but whatever's happened with the rest of the proceedings, the wife would still be able to attack those remaining trust assets.
I'm not sure why. I mean, if the trusts are genuine, then the husband has no beneficial interest in them, other than prospectively as a beneficiary who may be the subject of an appointment. But if he's not within the class, he's got no interest in the assets, either for the purpose of execution of a judgment against them by a judgment creditor or a wife.
No,
I mean, trusts are trusts.
Yes, but they're nuptial trusts, and therefore they can be varied by the court, and therefore the court can get in and rummage around in those trusts. If we've been unable to get them set aside, whatever has happened in the rest of the case, those trusts, the residual assets in those trusts after repayment of the loans, which would fall into a bankruptcy, would be available to the court for variation.
That's by, and these are creatures that I'm.
Your
familiar with,
lordship
okay.
was asking earlier about sections 22 to 24A, I think, of the Matrimonial Causes Act. Section 24 gives the court power to vary nuptial settlements. These are plainly nuptial settlements.
Right. Okay. Thank you.
Husband and wife are both beneficiaries. So there is that possibility of that separate side pot remaining available for the wife's claims, which is why, and knowing what I do about the assets in that, that's why I say it may well be that if the provision was to be made for her, it could be made out of that, in accordance with the prenuptial agreement. The residual assets in the trust may be sufficient for that. I'm not making any concession that the applications to set aside those trusts aren't thoroughly good and should be successful, but I acknowledge that they might be unsuccessful, and in that way, there could be the two pots that your lordship posited earlier.
Okay. Yep.
Assets still available for a claim by the wife. Having said which, now that we see that the wife already has assets of 25 million of her own, that may not. We don't know, of course, is what the asset position was at the time of the prenuptial agreement. And that's one of the things that my lady doesn't know either. So when posing to me earlier, well, is that really enough for a wife married to a man with this much wealth? Well, we don't know because she's got 25 million of her own. We don't know how much of that she already had in 2011, if any. We don't know whether, if in fact she's got that since 2011, that makes seem more fair what she was getting under the prenuptial agreement than it might have done if she didn't have any other assets. So these things are complex, but what one can see is that there was nothing wrong with what Mr. Justice Peel did in making his order, or rather refusing to make an order just yet. Just want to go back, though, to the last way in which we, the bank, are prejudiced, would be prejudiced by the making of the order. Going back to Chancery Division to make an application to unfreeze, the possibility that that's successful, but even if it's not successful, what happens, Mr. Justice? So sorry, we learned from Mr. Howard would say, well, it's only 4% of the assets, so she comes and stands along with the other creditors as to 4% of the total wealth. Well, 4% of these sorts of numbers is a lot of money. And if she shouldn't have 4%, because 4% was a figure that was plucked out the air by the husband and the wife in arriving at what they arrived at in their agreement, then we're prejudiced by her having a larger claim against the insolvent estate than she should properly have. And those are all real prejudices. Prejudice that the wife suffers, I've already dealt with the question of death. And the only other one that's really even remotely cogently argued is there's delay. And we acknowledge that there's delay. And my learned friend, Mr. Turner, said something that we agree with, which is that delay has to be seen in the context of it already having been 6 years since they reached this agreement. Quite so. If we were positing a long delay now, after a short period, that would be much more prejudicial than extending what's already been a 6-year delay to await the outcome of the Chancery proceedings. And so, in my respectful submission, the case made by my learned friends, Mr. Turner and Mr. Howard, falls far, far short of establishing that Mr. Justice Peel should not have made the order that he did make. That one could easily imagine the whole case being reversed, Mr. Justice Peel having approved the order, we had applied for permission to appeal, and I would have been having to argue, no, he could not have made that order, and that may have been difficult too, because the reality is that he has a discretion. He exercised that discretion carefully. He considered the competing arguments. He decided in the end that the delay until the conclusion of the Chancery proceedings was a necessary price to pay to ensure that an appropriate order could be made on the wife's application at once the true facts were known. If my lady and my lords would forgive me whilst I turn my back for a moment, I have got some other things to say, but I'm beginning to think that they may not be things that will be as useful as I once thought that they might be. Yes, I'm going to take this point incredibly shortly. it's a point that really it's made forcefully in the judgment by Mr. Justice Peel. He relies in the judgment on the judgment of the Court of Appeal in Zidias as being the essential justification for not approving the order, being the foundation not to approve the order. There's a long quotation that he gives in the judgment. We're in tab 7 of the core bundle. It's paragraph 29. I know that the court will all have read that. It can be summarised in this way, that the court retains, even in the case of agreement between the parties, not just the right, but the duty to scrutinise the order. And again, without taking the court to the authorities bundle, my lady's judgment in Haley and Haley reiterated that. Ladyship goes through the jurisprudential history of the court's role when presented with a consent order, and there's the menagerie of bloodhounds and ferrets that the court is not required to be. The court is entitled to act as detective, not required to be bloodhound or ferret. And in my respectful submission, what Mr. Justice Peel did was absolutely in accordance both with what was said by this court as long ago as 1998 in Zidias, but of course much more recently by my lady in Haley in 2021. If you'll, I now just remembered there were 2 points that my learned friend Mr. Turner made that I had intended to specifically deal with. My friend Mr. Turner says that by mentioning the damages claim and by saying that the order is not to be enforced until that damages claim has been resolved or the freezing order has been varied, amounts to having regard to the potential liability. Whilst one might say as a matter of semantics that is right, that is not the kind of having regard to a substantial liability that is ever practiced in the courts. The court does, of course, from time to time in relation to liabilities which can be dealt with by way of contingent orders, one way or the other. Very common for there to be a potential liability which may or may not arise. If it does arise, the wife will repay the husband 50%, 40% of that liability if it arises. That's easy peasy in a case where it's a small liability against a bigger background. And sometimes one has to just take a view about a liability. If that arises, too bad, the husband will be poorer than it seems. And what makes this case different is, of course, that it's we've used the phrase elsewhere, existential liability. If it arises, it is essentially it's a wipeout for the husband. I've already dealt with that. I've dealt with that. I don't think I need to trouble the court with any of the other points that I was going to make, and those are my submissions.
Could you just tell me what date the trial is due to begin? I was originally told June.
The 6th of June, my lady. Is that the first reading day, or is that the first day in court?
So
the 6th is a reading day, a week. It's a week of reading, I'm told.
Yeah.
I think the hearings start, therefore, on the 13th.
Has it been extended, its time estimate? Because I think someone said it was going to go on until November.
I think that's only because of the vacation. I think it splits
Understood.
over the vacation.
It's due to stop on the 17th of November. That'll be the last day, obviously before judgment.
Thank you.
Unless there's anything else I can...
No, thank you very much, Ms. Watts. Anything in reply?
And then on dates of the proceedings in the Privat Bank damages claim, of course, one can't rule out the possibility of appeals, whichever way it goes, appeals to however many levels, and how long that will take both to get them listed and arranged and take place. So there's a prospect for a very long period of time yet before that those damages proceedings are concluded. Mr. Marks hangs his hat on Section 33A of the Matrimonial Causes Act and says the judge was entitled to inquire into this proposed consent order. And indeed, we expected the judge to inquire into it, which was the very reason we sent the letter of the 7th of December to the court, flagging up various of the prospective issues in it and asking for an oral hearing and asking to have it listed in front of a High Court judge, because we realised it was not a straightforward piece of boxwork. It gives the power for the judge to inquire, and Mr. Marks says, well, the judge could then have either made the order, and he might have had difficulty complaining if the judge had made the order, or not making the order. And he says we should have difficulty in making out an appeal because the judge didn't make the order. Well, of course, it's often called a discretion, but it's a discretion that has to be exercised on a principled basis, and it has to be exercised taking into account the proper considerations and leaving out of account improper considerations. Mr. Marks says, well, Mr. Justice Peel clearly had in mind all sorts of things, potential dodgy dealings on the part of the husband and wife, and he draws attention to the fact that the prenuptial agreement was less, he says, than the amount that the wife would receive under the proposed order. Of course, if you look at the prenuptial agreement, which the judge had, so there was no hiding that from the judge, he'd got it as part of the papers in front of him. He quoted from it right at the beginning of his judgment, the essence of it. And part of it, of course, was £500 per month for, sorry, £500,000 a month for the wife.
Not a month. A year.
I get it,
Even
for
at
life.
this scale, that would be a lot.
For life, yes.
Doesn't say.
We've done a quick calculation, and we think that that's, well, for a wife whose age was 40, and this wife is younger than that, that was on a Duxbury base, that would be 14.6 million if one capitalised that. So it was actually quite a substantial prenuptial order, but leave agreement. But leave that aside for one moment. Mr. Marks says, well, the judge clearly attached importance to that difference. Can I take the court to supplemental bundle, page 141? Because Mr. Marks was complaining about, tab 10, I think it is, was complaining about not seeing all sorts of documents. And if I can make clear, the reason documents weren't readily disclosed was because the bank wasn't even a party at that stage. And these are confidential matters. And there was an issue as to whether the bank was entitled to even be there, let alone have access to confidential matters. But insofar as the bank did then have access, it was only to material that had potential relevance to the issues that were before the court. And I've already this morning highlighted what the judge regarded as the issues, whether there was prejudice or potential prejudice to any of the parties, or whether there was potential prejudice to the bank, and balancing those potential prejudices. So what did the judge say about the prenuptial agreement being less than the separation agreement and the proposed order? Letter H on page 141. Mr. Justice Peel, if, for example, there is a difference, a significant difference between the premarital agreement and the separation agreement, so what? And the judge went on in the course of that debate to and fro, and if you look at the following pages, 142A, 143, 144A to C, 145D to E, you'll see the judge making it clear that he wasn't interested in dealing with allegations of what were referred to there as jiggery-pokery. But that hasn't prevented Mr. Marks carrying on with the nudge, nudge, wink, wink, and now attributing that to the judge and saying, well, that must have been what the judge had in mind when he refused to make the order. Well, it clearly wasn't. We know what the judge takes.
Sorry, is this a transcript? This is a transcript of an earlier hearing.
Yes, from the...
And the judge does say there's, in a number of places, there are various things, these can be dealt with on the 9th of June, which is the date of the hearing that gave rise to the judgment.
Yeah, but he dismissed the application for disclosure of documents, and he certainly...
But that's not appealed. We know that, and there's no appeal.
Sorry, Millie?
We know that, and there's not been an appeal.
No, quite.
So I'm not sure where this is going.
And there was no discussion at all about the jiggery-pokery, although every time Mr. Marks in his position statements always puts in all sorts of stuff about, well, this, that and the other is very suspicious. But the judge, in any event, didn't purport to rely on that in his judgment. So when you're looking at the justification for the judge making the decision he did, rather than the other way, which he could have done, did he take account of the right factors? Did he fail to take account of any relevant factors? We look at that judgment, we know the factors that he did actually take into account were, number one, potential prejudice to the husband and the wife. Well, no prejudice that one can conceivably think of to the wife. As far as the husband is concerned, Mr. Howard has already dealt with that. He disavowed any wish to be protected. And the judge also referred to potential prejudice to the bank. But at that stage, the only potential prejudice to the bank that was relied upon was the risk of the wife going along to the court, the commercial court, waving an order and saying, there you are, that means I'm pretty much entitled to it. Now, as Mr. Howard pointed out earlier on, well, the wife could have gone along and said, well, here's an agreement, I'm entitled to it, and make an application anyway. But simply waiving the agreement and saying, well, that concludes it, it really isn't realistic. As I said earlier, in these circumstances, the bank would have said, well, hang on, this was made without taking account of the actual damages, and look at what's said on the face of the order. By the way, I ought to refer to the letter that Mr. Marks mentioned, where it was said that an application would be made. Because if you look at that letter, it didn't say the wife would be making an application.
No, it was the husband. Well, Mr. Marks said that.
It was said that the husband would be making an application. So there's nothing inconsistent between that and what's said on behalf of the wife. Although thinking about it, it actually might be a better idea than we'd thought originally, bearing in mind some of the points your ladyship made. But the wife has not sought to mislead anyone. The paragraph in her witness statement, which of course the bank didn't even have, but the judge had, and the judge also had the D81. So the discrepancy where she says, I've only got 4 million left and no other resources, I think, and I'm speculating here, what she's saying really is the 4 million is all I've got left of the 7 million that the husband has given me, not 4 million left altogether, because she completed the D81s. It would be an odd thing for her to do if she was trying to mislead the court, to put all that detail in the D81 and say something different with an intention to mislead.
I think the next, I understand the point about the two. It's the next sentence, I think, that also causes a little bit of a question mark.
Which one was that, Lord? Sorry.
I mean, you may be right in relation to the 4 million, But she then went on to say, I have no other financial...
Yes, that was what I think I did actually say that just now. And I think that there must have been some confusion there, because clearly she knew she did, and clearly she was telling the court she did, because it was in the D81.
Yeah, okay.
It wasn't something that would have misled the bank, because the bank didn't even have it, this documentation. But what does all this go to? It doesn't go to anything which the judge expressed as justifying his decision. What he had were things which I suggest were illegitimate considerations. First of all, to protect the husband who doesn't want protection, and to protect the bank against this prospect of prejudice by husband, wife, whoever, going along and trying to persuade a judge in the commercial court that this order meant that the matrimonial court was approving, as it were, when clearly on the face of it, it says it's entirely a matter for the judge in the commercial proceedings. And it's clear that the judge in the family court wouldn't have been able to take account of the potential outcome of the commercial proceedings, because nobody knows what that is. What was not mentioned at all in the proceedings below was the point raised helpfully today by my Lord Justice Snowden about bankruptcy. Not a mention of that. The judge hadn't sought to justify his order by reference to the wife being able to prove in bankruptcy for the full claim, which hadn't taken account of any 4.6 billion if there be a judgment for that claim. Nothing at all about that. But if it had been raised, then the sort of answers would have come, the sort that Mr. Howard has made this afternoon. Well, actually, the bulk of the money that's going to the wife came from was made in periods before the events which give rise to the damages claim. The £60 million property in London, the 65 million or whatever it is that was loaned to the trusts. So those would have been matters that would have been relevant if that had been raised, but it wasn't raised. It may have been a relevant point to consider if it has been raised, but it wasn't. The only points that the judge took into account to justify his decision were those two that I've harped on about probably for far too long now.
But can I just ask you to look at the end of paragraph 31 of his judgment?
One moment, I'm sorry.
In fact, it's probably best to read the whole paragraph 31, just to remind yourself of it, but it's particularly the last sentence of it.
Just a moment. Paragraph 31. Of course, Zidias, which was referred to, which quoted just there, was a protection of parties situation. Paragraph 31, did you
Yeah, I mean, the run-up starts at paragraph 30.
Right.
As it were, so
yes.
Take a moment to...
Yes, of course, the end of paragraph 31 makes it clear that he's seeking to protect the husband against himself.
Well,
Talks about incapable of compliance, but no mention of bankruptcy proceedings or the significance or potential significance of bankruptcy proceedings.
No, but what he is doing, at the end, what he appears, at least on the face of it, at the end of 31 to be doing, is to adopt an approach that says, I have to assess what is the net assets of the parties, by which he means the net asset of husband and wife. And because of the scale of the potential liabilities of the husband, I can't do that with certainty or in any safe manner. And therefore I can't make an evaluation of whether the outcome of the proposed consent order is fair, which I'm required to do by section 33A.
But
I paraphrase.
that raises the question why did he have to
And so
ascertain?
my question to you was going to be, do you say that that is an error of law?
I do. And of course, what he was saying was the reason why I have to do that is because I might otherwise do unfairness to the husband, or I might do unfairness to the bank.
Or wife or both.
not because-
Potentially unfair to either or both.
Either or
parties,
both,
what he
yes.
said. So your emphasis that it's just unfair to the husband, it's either or both. He just doesn't know.
Yes. But certainly the only unfairness to the bank that had been raised was this point about...
We have your point.
Yep, sorry. So we weren't in a position to address that because it was never raised. And the judge was, as he said, right at the case management hearing, regarding the issues in the case as those questions of competing potential prejudice. So we say, well, whatever you think of the chances of prejudice occurring to the wife, we say the greatest prejudice is actually the priority supposedly being given to the bank if it succeeds. But it's not a question of there only being limited prejudice to the wife. It's a question of, was there any prejudice to the wife? What prejudice was there to the bank on the judge's findings that could legitimately justify this order? That's why we say this matter should go back and be considered, bearing in mind some of the points that have been raised today. And the longer Mr. Marks went on, the more that became apparent when he started to say things such as, well, we might not have objected to the original prenup being made into an order. So, as I said earlier on today, the assessment of all this was perhaps a little superficial, and of course the longer one goes on thinks about it, of course we're as much to blame for that as anyone else, but it ought to be investigated more thoroughly before the wife's and husband's joint application for approval of that order is dismissed, so those points can be addressed properly on a properly informed basis.
So the outcome you seek is that the appeal should be allowed and remitted for rehearing?
Yes. Whether before Mr. Justice Peel or any other judge of the High Court.
You made much in your opening of prejudice to the wife because of the risk of death. That was addressed by Mr. Marks when he stopped talking about some of the things he'd discovered, and he said Mr. Justice Peel had made clear findings about that there was an obligation to deal with that under a will, and you've not replied to that. Did you want to?
No, I simply said the judge didn't actually address that properly. He said, well, couldn't you deal with it in this, that, or the other way by making wills? To which we said, well, there's all sort of problems with that. Look at the problems, if you read the wife's witness statements, the problem she had getting her husband to make wills initially in these proceedings. There are properties, who knows where, that will have to be addressed in a will. It's not the same as having a claim. So we say that was an inadequate evaluation of that point as well. Although that was just one of a number of points we said created prejudice. We don't say that there will necessarily be prejudice, but there was potential prejudice in all sorts of ways to the wife and none to the bank, and albeit obviously potential prejudice to the husband, not prejudice that he sought to rely on or complain about, and which he disavowed, as it were.
Thank you.
Lady and Lords, those are my submissions in reply.
Thank you very much.
Thank you.
Mr. Turner. Well, thank you all very much, not just on the front bench, but junior counsel and solicitors. I'm very aware of how much time and effort is taken in putting together an appeal of this nature. It won't surprise you that we will be reserving our judgments. I can't tell you precisely when they will be ready to be distributed in draft, but they will be distributed in draft in the normal way. That's for typographical, grammatical and minor factual errors, not for an opportunity to re-argue the case, please. And may I remind you all of the new terms of the embargo that will appear on the draft judgment. This is a case that may generate some interest, and it's most important that the confidentiality of the draft is preserved until such time as it's formally handed down. That, of course, is important for all of you as well as for the court, because it means if we've had to make any alterations or amendment, we've been able to, in the light of your observations, we've been able to do that. Thank you all very much. Oh, yes, I think you've had a transcriber. I do apologise, actually. I didn't see if your transcriber wanted a break at any stage. I'm so sorry for your head.
It's a bit late now.
Probably have to go and have a lie down now. Many apologies, that was very discourteous of me. I presumably will be given copies of the transcripts, please, if they could be sent through to my clerk. I don't know who's got carriage of that. Thank you, I think it's the man. Very well. Thank you all very much.
All right.